Thank you very much. Thank you, Lucy, for this kind words. Well, first, thank you very much, Professor Schmücker, Professor Dreyer, here he is, for inviting me. I'm very happy to be here. It's really very stimulating. I couldn't come to the fall event, so I'm now really happy to be part of this one. So this what I'm gonna present today. So by the way, you understood I'm a lawyer. You know, I'm wearing a tie. You know, always. Yesterday, Professor Rigamonti also wear a tie. Must be something about lawyers that they have to dress up like in a costume or something like that. But so anyway, you recognize me, and I will do a law presentation. And trying basically to fix some of the things that we discussed during these 2 days with legal reasoning. So it's a work in progress. So I don't have all the details, and so pardon me if some things are not discussed in all details. It's the first time I present that to an interdisciplinary audience, so I'm really looking forward to your comment. It's a broader project on freedom to create, freedom of artistic creativity, and copyright law, so this is my first take on that. And I think it's very important to start with defining where we're coming from. Lucy raised the issue, and I think Till also yesterday, trying to say, well, first we need to actually tell what the copyright system wants to achieve, and I'm going to propose my assumption on that. I think copyright law is a tool to provide incentives for authors to create for the benefit of society, through the securing of a fair remuneration for the use of their work. So this is important, this is my assumption, and I'm gonna try to explain where this could lead me with respect to the copyright system. So in order to enable future creativity, we know that some users are kept outside the control of right holders, through limitations to the exclusive rights. So these limitations, alongside the exclusive rights, can have an essential role to play when it comes to provide for a good and vital creative environment. Now we know that these users can be either free of charge or lead to the obligation to pay a fair remuneration to the creator. That's the case, for example, in Europe with respect to private copy, and we'll get back to that in a moment. So what is interesting to see is that these remuneration can sometimes provide significant revenues for creators, and so I think they constitute a very interesting tool for legislators to secure that creators can participate fairly to the creative reuse of their work. The problem that we have at the moment, when you want to create a derivative work or a dependent creation, what I mean by that is when a new work incorporates a creative reuse of an existing protected work, you do not have a specific limitation in the statute to allow for a creative use. On the contrary, very limited options exist. And what happens most of the time, if I'm a creator, I want to create a derivative work, I have two options. Either I clear the rights, let's say I search for the right owners, and sometimes it can be very difficult to trace them. Sometimes it's their heirs, and sometimes it has been assigned to many people. So if I'm a creator, I can face some difficulties. I risk blocking situations. And sometimes the heirs, for example, or the right holder, or even the creator might say just, no, I don't want you to use my work. Second option, and that's the most frequent one, especially on social media, I accept that I'm an infringer and I take the risk of litigation. For example, I make a picture of a protected work, I post it on my Facebook, and I see what happens. And most of the time nothing happens because there is no commercial use, or there is no commercial exploitation of the work, and so there is no reason to litigate. Now, let me just get back a little bit to the basics. There is this assumption amongst copyright specialists, at least that's the traditional perspective, that when you, and this is very important because this is taken over in the policy debate about copyright, and this idea is the more you have limitation to the exclusive right, the less you would have innovation. And I think this is not necessarily true. On the contrary, this is something I will try to demonstrate in my talk. I think that a well-designed limitation system can have very beneficial consequences on creativity, while also adjusting the balance in favor of creators. Now, this has been said by a couple of scholars. There have been some studies, and what is interesting is now that slowly you can put some numbers, some figures on also the interest of keeping some free spaces in copyright law. One of them is a study that was made by the Computer and Communication Industry Association that basically says that fair use intensive industries are responsible for 23% of the US economic growth. Some similar studies have been made in the EU, although you can also discuss their methodology at the end, but there is at least some measuring that is taking place. What is interesting that we see that more and more very innovative businesses, the new internet economy, such players such as Google, who basically build their business model on the free spaces left in copyright law, and this generates growth and innovation. Now, what is very important in that discussion is that we have to make sure that at the end of the day, creators get an equal share of the cake, because for now, it seems that authors have always been the big losers of the copyright game, and that's why I think it's very important that you needs to secure also some kind of remuneration. What I call limitation-based remuneration rights. They're more frequently called statutory licenses in the legal discourse. Basically, the idea is the following: the copyright owner cannot say no, but he is entitled to receive a fair remuneration. That is what Jane Ginsburg, a US scholar, has recently called permitted but paid. And this option is very long established in many European countries for certain limitation and exceptions. We know the private copy exception, for example. Many countries also have this system for reproduction, for education and research purposes. And actually what we see, and here also there are some very interesting figures that show that these remuneration rights provide substantial revenues. there is approximately 550 million euro per year generated for the private copy exception. So that's a whole bunch of money. This could also be extended to other exceptions and limitation, but only for these. For the private copy exception, there is a lot of revenues that are generated. Now, a word on terminology. Sometimes you hear this concept of statutory license is also called copyright levies, liability rules, statutory licenses. Now, this is not totally irrelevant. It might be a little bit too much of a legal discussion, but liability rules come from this idea of tort law, there is a harm that needs to be compensated. What I would like to look at this system is just to look at these statutory licenses as an alternative mechanism to the exclusive right to remunerate creators. And that's why I call them limitation-based remuneration rights. So what's the focus of this talk? Let's look at statutory license and see if they can offer a satisfying mechanism, also in other contexts than in private copy or research exceptions, but to address the issue of creative reuse of copyrighted works. So, well, it was mentioned before, both exploitation rights and copyright limitation share the same goal, the promotion of creativity. The copyright clause was already mentioned. Now, if we take that perspective, basically, if it can be shown and demonstrated that the objective of the copyright system can be achieved by a greater curtailment of the exclusive rights using copyright limitation, then there should be no objection to it, because copyright has to serve a certain function, has to do the job, and basically we don't care if it's through exclusive rights or through a non-exclusive system. That's a problem so far. These issues are often dealt with from a very ideological standpoint. But that's not all. We know that, at least in Europe, and this is very important, to foster creativity is not the only objective of the copyright system, but the protection of the creator builds another essential basis for the system. Now, when you look at copyright limitations, there are not necessarily, and I mentioned that before, free uses, and they're not always free of charge. The directive for copyright in the information society gives the option to legislators to provide remunerations in the context of exception. And if you take, for example, Germany, it's a very author-centered system, but it is a country which has a lot of exception and limitation, and most of them are remunerated. So copyright limitation can actually be seen as a protection mechanism for the interest of creators. Why is it so? Because these payments that are generated by limitation-based remuneration are in many cases much more interesting for authors than the royalty payment they receive from contracting parties. If you're an author, if you are successful, you can maybe negotiate a 7-8% royalty rate. For most of the remuneration system such as private copy, most of the time the share is 50% to creators. And that's a significant difference than with contract law. And if we understand the recent Reprobel decision of the Court of Justice, this might even be, maybe potentially, we don't know, the entire 100% of the cake. So this is one aspect. It's very interesting for creators and not necessarily for right holders. What is interesting also is that most of these remuneration systems are inalienable. So they cannot be waived to the right holder. And that's, of course, very important because we know that authors that sign whatever is presented to them, they do not care about the contracts and give away their rights. This is not the case through these systems, so they keep these rights no matter what happens. So we can see that alongside a protective contract law of creators, these limitation-based remuneration rights can provide additional suitable instrument to achieve a balance of interest between the publisher and the author. And that's very interesting because we think a lot about the balance between right holders and the public interest, but we will also want to have the creators on board to support the copyright system. So we see that certain courts in Europe have already seen very clearly the potential of these limitation-based remuneration for an effective protection of the creators. We see, for example, that the German Supreme Court, in a decision of 2002, adopted an extensive interpretation of a limitation for a press review to allow electronic press review with the argument that is much more beneficial for creators. Why is it so? Because this use was attached with the payment of a fair remuneration for creators. So broadening the limitations to copyright law is, there is an interest, a remuneration interest for creators. And the Supreme Court in Switzerland has adopted exactly the same position 5 years later. So I've just said a word about these terminology. Of course, there is ongoing a debate, especially because we have different traditions in Europe when it comes to these remuneration rights. There has been, for example, a question of terminology. Should we talk about compensation or should we talk about remuneration? And there is a famous case that went up to the Court of Justice where there has been a debate between the Advocate General who said it's a reward. These mechanisms are a reward, and the Court of Justice afterwards said, no, it's a compensation for a loss of the creator. But if we get this idea, if we accept this idea that remuneration is a reward, then there would be two mechanisms, the exclusive rights and the limitation to achieve that goal. So now, why the exclusive right can hinder creativity in the context of derivative work? Well, what if for example, a creator intends to create a new work based on another one, and the original author refused the authorization or asks simply for a too high price? He says, okay, you can use it, but you have to pay a huge amount of money. And basically, courts were faced very often with this situation. And basically, some courts have tried to find solution in that context. we talked about sequels earlier on, and there was a very famous case that went up to the French Supreme Court about the sequel of Les Misérables from Victor Hugo, written by a contemporary author. And the heirs of Victor Hugo, of course, the work is in the public domain since a long time, but in France, the moral rights is perpetual. So the grandson of Victor Hugo sued on a violation of moral rights, and he won in the second instance because that's just moral rights, how they function, that's just copyright law. Now, the French Supreme Court didn't accept that argument and say there might be a need to balance these different positions, and had the freedom of artistic creativity, which is protected under the freedom of expression clause of Article 10 of the European Convention on Human Rights. And they said, basically, if the work is in the public domain, then freedom of artistic creativity should prevail, balancing outside copyright law. Now, we discussed yesterday already the decision of the German Constitutional Court, Germania 3, so I will not draw on this, but maybe another decision of the French Supreme Court about appropriation art, which is quite recent and it might be of interest to many of you, because it was a French artist from an appropriation art movement that used some fashion photograph in his paintings. Of course, he got sued because it was a copyright violation. It was not a quotation. He could not make this argument. But here again, the Supreme Court said, wait a minute, of course, it might be a copyright violation in the books, but here the court should have waived the different interests and also to see that there is a new work that is created afterwards by the appropriation artist, and there is also something which is worth protecting through the freedom of art protection of Article 10. And we know that the case law from the European Court on Human Rights on freedom of expression is particularly strong in Europe as a consequence of World War II, and we know what happened then. So, but before looking into outside of the copyright system, let's have a look of what are the options that we have within the copyright system. Now, these options are not very promising. We do have quotations, but they're often restricted to the field of text. Quotation for artistic purposes are very common in the artistic field, but in the legal field, they're most of the time not accepted. I heard from Till that there was some discussion in Germany about extending this quotation, but this is not law for now, and in most of the European countries that would not be permitted. You would have parody, okay? Parody, but then most of the copyrighted system in Europe ask for a humorous or a satirical view on the original work, so you have to make fun of it. If there is no fun involved, or some courts even say you have to smile when you see the work. If this is not the case, it will not be admitted. And then you have a strange provision in German copyright law, which is I think, underexploited, but because it's most of the time interpreted very strictly, the idea of freie Benutzung, free use, but as said, it has never been really applied in such a context. So this is for Europe. In the US, you have a little bit more flexibility, of course, because you have this fair use clause. And basically, we have some decision of the Supreme Court that allowed derivative works, also in the commercial context. For example, with the case of the use of the song Pretty Woman by a rap band, Two Live Crew, and that was accepted as being fair use. You also have a lot of decisions from appropriation art. Jeff Koons is one of the regular customer of courts. We mentioned him many times. But here again, basically it's 50-50. Sometimes he wins, sometimes he loses. So what about legal security here? I'm not sure we can have the predictability that we wish when looking at these decisions. So basically artists, again, appropriation artists, if they do not want to risk, and if you are Jeff Koons, you might maybe afford to going up to the Supreme Court. If you're not as famous as he is, you better be advised not to take the risk of that litigation. Okay. So the alternative solution would be maybe that we just introduce a specific exception. We design, as lawyers, a specific exception for creative reuse of copyrighted material. Now, this is something that is in the copyright discourse, legal discourse, since a couple of years. It's called a user-generated content exception. This whole option has been proposed in 2008 by the European Commission. It didn't last very long because it was totally lobbied against, and the proposal was dropped almost immediately afterwards. There is a new attempt that was made in front of the European Parliament. It's a pity that Julia Reda is not there. So it has been totally watered down at the end, also through the actions of lobbies, but it's still mentioned as a wish to develop in the future in her report. Now, it has been implemented in some legal system, and for example, Canada has introduced a provision on user-generated content. Here it is. Okay. So you don't have to read it. That's certainly not what we are looking forward. I dedicate this slide to my friend Cyril, basically, who has full trust in legislators to come up with good balancing. Well, that's basically the result. It's, you get a headache when you have to read it. And there are so many, conditions and different basically carve-outs that at the end you do not know what is allowed or not. So this is not what we want to do. And basically courts will in any case try to come up with a very narrow understanding of that. Why is it so? Because the main problem with this is that this provision provides for an authorization to use, but which is free of charge. So this might be workable in non-commercial context, and by the way, it's not easy to draw the line where it's commercial and non-commercial. We have seen this in many cases, but this might be clearly a problem in a commercial context. If you talking, for example, about a film which is made out of a famous book, such a provision would be problematic. So, and what I was saying is that court will try to narrow it down. So we do not have a solution from these kind of provisions. So what can we do? So next, if we are creative, we could try to come up with an exception limitation based on competition law, antitrust. An interesting attempt was made in the proposed VITIM European Copyright Code, which is a work made of scholars try to propose an ideal copyright law for Europe. Then you might try to draw a parallel with patent law. In patent law, you have compulsory licenses based on reason for a dependency. So when you have a dependent creation that builds from an existing invention, you might be able to get a compulsory license for dependency. What is the disadvantage of that? The disadvantage in this case, this license has to be ordered by a judge. That means that authors will have to go into court, face very long proceedings. If you want to have a decision from the Court of Justice, you have to count 10 years and you have to go in front of all the different steps in order to know, can I do this or can I not? And that's, of course, not really satisfying. So we have to look into other type of mechanism, non-voluntary mechanism, statutory licenses. Now I will skip the legal obstacles to that. Some might raise the three-step test. These are discussion for lawyers. Also the constitutional protection that is often raised when you try to come up with some very interesting ideas. There's always someone saying this is against property. I don't think this is really a very convincing argument, but I have to skip it for the interest of time. So how can we secure a fair remuneration after all? Well, that's what I try to advocate by providing an unwaivable right to equitable remuneration for the initial creator when the derivative work starts to generate revenues. Now, how to calculate the shares? You have two mechanisms in law. Either the share is established by law, the 50-50 share that I mentioned for private copy, or it is negotiated. So it does not, this case, for example, the amount of the remuneration can be negotiated. For example, if the original creator and the derivative creator cannot agree on a price. For example, for the book of Harry Potter that needs to be used to make a film, if they do not agree, then it could be mediated by a regulation authority. I call this regulation authority the Observatory for Access to Copyrighted Work. I'm happy to explain you more in detail what I have in mind, but I'm running out of time. So here is my conclusion. I try to explain that I think that statutory license could be a workable option for certain creative users, provided, and that's very important, that a fair remuneration is secured to creators. This could be guaranteed through the implementation of an independent authority that could check that the access is granted at a fair price, taking into account the specificity of the work in question. For example, if you're the right owner of Harry Potter, or if you're the right owner of a totally unknown book, of course, the price will not be the same if you want to make a film out of it. If you want to make a film for the Polish market in Polish, the market will, of course, be very reduced or reduced to the Polish population. So the price cannot be the same than if it's in English for the US market, etc., etc. So all these specificity can be basically taken into account. More fundamentally, I think we need to rethink copyright as an access right, meaning a right to grant access and not to hinder it. all the fact that we discuss on all this artistic situation copyright issue is already, I think, a problem because it disturbs artists when they create. I think copyright needs to become a right to say yes rather than a right to say no, as an could be thought as an inclusive right rather than an exclusive right. And again, I think claiming access does not mean access should be necessarily free, but just that it should be possible under fair conditions, and that copyright should not block future creativity. Thank you very much.